forgive me. Forgive me my fumbled fingers.
Okay.
So you'll sit.
Okay, so I can start right now.
Yeah.
Okay. All right.
Right next door.
Okay, thank you. Hello, my name is Judy Owens. I will be your presenter today on our Center for Smoke-Free Policy presentation called Smoke-Free Legislation, History, Policy, and Implementation. My name is Judy Owens. I am a 1992 graduate of the University of Kentucky College of Law. I practiced in Eastern Kentucky for a number of years in the areas of workers' compensation, in plaintiff's work at a different time, and then finally in the county attorney's office. At that time, I left legal practice. I worked in Governor Patton's administration on behalf of people with Appalachian issues. I eventually ran the UK Center for Rural Health, which I left in 2006, and I have since been doing some contract work, including work for the Center for Smoke-Free Policy. The purpose of this presentation is to help acquaint you with smoke-free policy in general and the state of Kentucky smoke-free policy in particular. Smoke-free policy, first I'd like to give you an overview of what we're going to be talking about today. This webinar focuses on the history of the development of smoke-free policy globally as well as here in Kentucky. We're going to cover health, public policy, and legal implications because each of these is vitally important to the development of smoke-free policy and to the legal ramifications of smoke-free policy. And upon completion, you should have a better understanding of the rationale behind smoke-free laws, the history, and the legal refinements as smoke-free policies developed in Kentucky, and the current state of the law in Kentucky with regard to smoke-free law. I'd like to address one housekeeping issue at this moment. I do want to note that this presentation has been approved by the Kentucky Bar Association for continuing legal education credit, and your certificate of completion will be available at the conclusion of this webinar. Smoke-free policies are nothing new. In fact, they're quite ancient. Smoke-free policies have been enacted for hundreds of years, dating back to 1757. King James I published a treatise on anti-smoking back in 1604, and various popes in the 16th and 17th centuries threatened excommunication to those who smoked. A counterblast to tobacco was the name of the treatise that James VI wrote, and James I of England, of course. He expressed his utter distaste for tobacco, particularly tobacco smoking. It was one of the earliest anti-tobacco publications. It refers to medical theories of the times, including the four humors. In it, King James blames Native Americans for bringing tobacco to Europe and complains about passive smoking. He warned of danger to the lungs, and he decried tobacco's odor as hateful to the nose. As I said, various popes in the 16th and 17th century threatened excommunication to those who smoked, notably Pope Urban VII. He was a 13-day pope, but he did last long enough to enact the first known tobacco use restrictions in 1590, when he threatened to excommunicate anyone who, quote, took tobacco in the porchway of or inside a church, whether it be by chewing it, smoking it with a pipe, or sniffing it in powdered form through the nose. The earliest citywide European smoking restrictions were enacted in Bavaria and certain parts of Austria in the late 17th century. Concerns about the addictive qualities of tobacco continued through the 17th and 18th century in Europe. So why smoke-free policy in the modern world? Smoke-free policy and advocacy was well documented in terms of the health effects for decades, particularly in the post-World War II era. But the watershed was in 1964 when the Surgeon General issued a report establishing a connection between smoking and increased mortality rates from lung cancer, heart disease, and emphysema. Several reports completed in the 1980s found that secondhand smoke causes severe health risk and that tobacco products are addictive. The Surgeon General, for example, William H. Stewart, had a three-part report from 1967 to 1969, following up on the 1964 report, called The Health Consequences of Smoking. In 1983, there was another major report that basically held that cigarette smoking should be considered the most important of the known modifiable risk factors for coronary heart disease in the United States. And in 1988, a report on nicotine addiction brought certainty where the 1964 report had hedged, concluding that cigarette smoking is addicting. So, delving in a little more to the 1964 report, the Surgeon General was Luther Terry at that time. And here he is making the announcement regarding the cigarette smoke and its health effects. This report was unique for a number of reasons. First, it focused entirely on the negative health effects of smoking. It noted that cigarette smokers had a 70% increase in age-corrected mortality, that cigarette smoke was the primary cause of chronic bronchitis. There was a correlation between smoking, emphysema, and heart disease. Now, these findings were important, but really there was a cultural change in the 1964 report in the United States. There started to be restrictions on the type of advertising that tobacco companies could do. Warning labels became required on tobacco products, and there were widespread investigations of some of the practices of the tobacco industry. The next major landmark in these types of reports was Surgeon General C. Everett Koop's 1986 report called The Health Consequences of Involuntary Smoking. It's unique in that it decisively portrayed secondhand smoke not just as an annoyance but a quantifiable health risk. Involuntary smoking is a cause of disease, including lung cancer, in healthy non-smokers, General Koop found. Compared with children of non-smoking parents, children whose parents smoke have an increased frequency of respiratory symptoms and infections. They also have slightly smaller rates of increase in lung function as the lung matures. Simple separation of smokers and non-smokers, Dr. Koop held at the time, within the same airspace may reduce but does not eliminate secondhand smoke exposure. This report also reviewed current policies restricting smoking in public. Subsequent important reports on secondhand smoke were Surgeon General Richard Carmona's 2006 report, The Health Consequences of Involuntary Exposure to Tobacco Smoke. This report concluded that there is no risk-free level of exposure to secondhand smoke. In 2010, Surgeon General Regina Benjamin also issued a tobacco-related report entitled How Tobacco Smoke Causes Disease. This report showed that even short-term exposure to tobacco smoke causes immediate damage to DNA, lungs, and blood vessels. In the 2006 report, I'd like to note that non-smokers exposed to secondhand smoke at home or at work increase their risk of developing heart disease by 25 to 30% and lung cancer by 20 to 30%. Secondhand smoke caused approximately 7,333 lung cancer deaths and 33,951 heart disease deaths in the United States in 2006. The source for this statistic is the American Journal of Public Health. The Environmental Protection Agency lists environmental tobacco smoke, also known as ETS, as a Group A carcinogen. A Group A carcinogen means that it is known to cause cancer in humans. How does secondhand smoke cause disease? When you inhale secondhand smoke, 7,000 chemicals reach your lungs. Your blood carries poisons to the entire body. These poisons immediately damage the DNA, which leads to cancer, damages blood vessels and causes clotting, leading to heart attacks and strokes, and damages the lungs, leading to asthma attacks, emphysema, and chronic bronchitis. The Surgeon General report of 2014 added conclusively that secondhand smoke exposure causes strokes. The most effective and least expensive way to limit exposure to secondhand smoke is by enacting smoke-free laws. Smoke-free laws have been enacted in the United States on both the state and local levels. The first United States state to enact a smoke-free statewide law was Minnesota. That was in 1975. The citation on that is Minnesota Statute 144-414. The first comprehensive statewide law was enacted in Delaware in 2002. Today, of the 60 most populated cities in the United States, all but 16 have smoke-free laws covering all bars and restaurants. Kentucky at this time does not have a statewide smoke-free law. A smoke-free bill has been introduced in the last 3 sessions of the Kentucky legislature. A bill was introduced in 2011 and was heard in the House Health and Welfare Committee, but was only presented for educational purposes, and there was not an intention to have a vote at that time. In 2012, there was also a hearing in the House Health and Welfare Committee, and at that time a bill passed, but there was not enough momentum for a full House vote. It was an election year, and many times in some jurisdictions this issue is controversial, and some legislators prefer not to have a vote on this matter attached to them when they're running for re-election. In 2013, there was another hearing before the House Health and Welfare Committee, and it also passed again as it did in 2012, and there was a lot of momentum in favor of this bill moving forward for a vote in the House. However, as the session wore on and as the vote became closer, some commitments were lost. The momentum turned and it became apparent that the bill would fail. So at that time, Speaker Greg Stumbo reassigned the bill to the Judiciary Committee for vetting for the main opposition argument, which had to do with property rights. After the judiciary hearing, there was no time for a full House vote, and therefore no legislation was passed. At the time of this recording, the General Assembly was considering a statewide smoke-free law in 2014, but there had not been a final conclusion. In spite of the fact that there has never been a statewide smoke-free law passed in Kentucky, local ordinances have proliferated. And you can see on the screen that there are a great many counties and cities in Kentucky that have coverage of smoke-free legislation based on local ordinances. Since 2003, 39 Kentucky cities or counties have enacted or adopted local smoke-free laws or Board of Health regulations. In Kentucky, 23 local laws or regulations cover all workplaces and public places, including restaurants and bars. They are considered comprehensive. You can always go to www.kcsp.uky.edu for updated listings, a map, and details of each of these local ordinances. 3 localities have laws prohibiting smoking in public places only. It's worth noting that ordinances like this do not protect all workers. An additional 13 localities have smoke-free policies with significant exemptions. These exemptions also leave many workers uncovered. Campbell County passed a comprehensive law on December 15, 2010, but a newly seated fiscal court repealed it on February 16, 2011. It's very important to note here that the main impetus behind developing a smoke-free law is to protect the public health, and particularly to protect the public health of people who do not smoke but who are exposed to cigarette smoke. If a locality does not implement a comprehensive law or a comprehensive regulation, then it is without a doubt impossible to protect everyone at work. It's very difficult to understand a scenario in which a person should be required to breathe smoke, which is a known carcinogen, while they're in their workplace. So that's from the health reasoning, that is that the purpose behind passing the law to begin with is to protect health. And if you don't have a comprehensive law, you really are not protecting everyone's health. Now, in some instances, health departments in Kentucky have used their authority to abate nuisances to public health by creating a health department regulation to restrict smoking. One such regulation is currently being challenged in Bullitt County. We'll discuss this more later in the presentation, but the health department won its case at the Court of Appeals, and now the case is on appeal before the Kentucky Supreme Court. From the vantage point of the Center for Smoke-Free Policy, comprehensive smoke-free laws are the gold standard. Why? Because it's the most effective way, and by the way, one of the least expensive ways, to protect all workers and the public from secondhand smoke. Exemptions are sometimes sought for political reasons or for practical reasons. But in the experience of the Center for Smoke-Free Policy and in other organizations nationwide, we found that exemptions, instead of building consensus, tend to create litigation points for cities and counties. There are numerous examples of this all across the country, but one well-known one involved the city of Louisville. When the city of Louisville decided to pass a smoke-free ordinance, there was a request made that they exempt Churchill Downs. Of course, Churchill Downs had been a very traditional place for racing, and one of the things that people felt like went along with racing was being allowed to smoke in the stands. So when Louisville passed its smoke-free ordinance, there was an attempt to give Churchill Downs an exemption so that people could smoke while they were at the races. But it was very quickly determined that there really is no legal basis for allowing one place of business to be exempt. And so eventually Louisville went with a smoke-free law that also covered Churchill Downs. As far as the history of developing local ordinances in Kentucky, Lexington was the first place to enact a smoke-free ordinance in Kentucky. This was enacted by a vote of 11-3 at the Urban County Council, and it was the first Kentucky smoking ban. It did have to withstand a trip to the state Supreme Court. The implementation was delayed after the law was challenged by a group of restaurant and bar owners who were backed financially from Brown and Williamson. But after it came back from the Supreme Court in the case of Lexington Fayette County Food and Beverage Association, 131 Southwest 3rd, 745, Kentucky 2004, the law took effect. Basically took effect in April of 2004. The benefits were quick and dramatic. Nicotine levels, which is a measure of exposure to toxic secondhand smoke, declined by 56% among bar and restaurant owners. Lexington had 22% fewer emergency room visits for asthma in the first 32 months after the enaction of the ordinance. The law was strengthened in 2008 to include all workplaces in the Lexington-Fayette County urban area. Smoke-free laws continue to be the most effective and economic strategy for protecting non-smokers from exposure to secondhand smoke. While it seems apparent that state and local governments have the authority to pass smoke-free laws, they continue to be challenged. What I'd like to do is examine the challenges that were raised to the Lexington ordinance so that we can get an idea of how similar ordinances have been challenged. Basically, the Lexington Food and Beverage Association challenged the ordinance on 3 grounds. First is preemption, second, property rights, and third, vagueness. These are typical of challenges that are made nationwide to these ordinances. First, let's look at preemption. The association argued that the smoke-free law was preempted by state law. Now, it might be useful to spend a couple of minutes reviewing the doctrine of preemption. The doctrine of preemption is derived from the Supremacy Clause of the U.S. Constitution. The Supremacy Clause states that the laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. In plain language, the doctrine of preemption means that there is a hierarchy of laws, where federal law trumps state law and state law trumps local law. In order for preemption to succeed, the U.S. Supreme Court relies on a 3-pronged test. Number 1, is the scheme of regulation so pervasive as to infer that Congress left no room for states to supplement it? Did Congress, in effect, preempt the entire field? Number 2, is the federal interest so dominant that the federal system will be assumed to preclude enforcement of state laws on the same subject? And number 3, does the state law produce a result that conflicts with the objective of the federal law? Now, if the case is of one of state preemption, that is, of a state law that preempts local, county, or city ordinances, these same standards would apply. So when the Kentucky Supreme Court examined the preemption argument advanced by the association, they rejected it. Their rationale was this: that municipal corporations have wide latitude under their police powers to create laws for the general welfare of its citizens. For this proposition, they cited the case of U.S. Mining and Exploration Natural Resources Company, Incorporated versus City of Bataville, Kentucky, 548 Southwest 2nd, 833, 1977. Under the 1980 Home Rule, cities may enact the cities may act without specific legislative authority from the legislature. So once Home Rule was enacted in Kentucky, cities are not required to wait for legislative action before enacting their own local ordinances. The case that the Supreme Court relied on for this proposition was Historic Licking River Side Civic Association versus City of Covington, 774 Southwest 2nd 436, 1989, and also the statute KRS 82.082. Finally, the association set out 5 Kentucky statutes that they cited as preempting the Lexington Ordinance. The court found that these 5 statutes do not meet the requirement of creating a comprehensive system of legislation regarding smoking. Specifically, the association cited KRS 217.005, which is the Kentucky Food, Drug, and Cosmetic Act, KRS 61.165, which governs smoking policy for state and local governmental offices, KRS 56.463, which authorizes the Finance and Administration Cabinet to adopt administrative regulations controlling state-owned and leased buildings, KRS 438.050, this imposes fines for those smoking on school premises, and finally KRS 196.245, which allows the Commissioner of the Department of Corrections to control smoking by inmates. The court found that these 5 distinct and narrow statutes did not create an intent by the Kentucky State Legislature to occupy the field, and therefore the state had not preempted smoke-free law in Kentucky in terms of localities like cities or counties. I would like to note that preemption arguments are rarely successful unless the state legislature has indeed adopted a statute that specifically creates a comprehensive state smoke-free law. I would offer the example of J.R.T. Colebrook versus Town of Colebrook. The citation is 829 Atlantic 2nd, 1089, New Hampshire, 2003. In this case, a New Hampshire city attempted to adopt its own smoke-free law when the state had already enacted one, and the New Hampshire Supreme Court held that the New Hampshire had already occupied the field and that a municipality was not allowed to enact its own ordinance. The second common argument that we hear with regard to the constitutional challenges to smoke-free law is that of property rights, and this one was certainly associated in the Lexington case. The association argued that the ordinance is invalid because it infringes on the right of a business owner to conduct his business without impermissible interference from the government. The Supreme Court rejected this argument, citing Adams Incorporated for the proposition that localities have the broadest field in exercise of police power and in the area of public health. This argument basically derives from the Takings Clause of the U.S. Constitution, that is, that no private property may be taken for public use without just compensation. In these cases, plaintiffs don't argue that there has been an actual physical taking of their property, but rather they argue that the municipality has deprived the owner of the beneficial use of his land. Again, the Supreme Court rejected this argument. Finally, the third argument that is often advanced is the argument of vagueness, and this was also articulated in the Lexington case. Basically, the association argued that the statute was unreasonably vague. They relied on phrases in the statute such as, quote, reasonable distance from the outside entrance of any building, close quote, or smoking paraphernalia, and they argued that those specific phrases were vague. The vagueness doctrine, just to articulate what the general principle of law here is, the vagueness doctrine was enunciated by the U.S. Supreme Court in 1972 in the case of Enacted v. City of Rockland. Citation on that case is 408 U.S. 401, and it sets out the principle on vagueness at 108. Quote, "It is a basic principle of due process that an enactment is void for vagueness if its prohibitions are not clearly defined." Close quote. So the standard for vagueness is a two-part test. Number one, whether the law gives the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he may act accordingly. And number two, whether the law provides explicit standards for those applying them to avoid arbitrary or discriminatory applications. In the Lexington case, the court upheld the reasonable distance provision. The court relied on Gurney v. Lexington Fayette Urban County Government. That's at 6 Southwest 3rd, 852, 1999, stating that a statute is not unconstitutionally vague if an individual affected by the ordinance would reasonably understand what is required of them. And of course, that language echoes the language in Enacted v. City of Rockland. The court, however, did strike down the smoking paraphernalia argument as vague. These arguments, preemption, property rights, and vagueness, are typical of those leveled against smoke-free laws. As in Kentucky, these opposition arguments are rarely successful across the country. Why is this? Because it's a long recognized principle of law that a municipality has broad latitude to adopt ordinances on the local level as well as regulations that promote and protect health, welfare, safety, and morals of its residents pursuant to the city's police power. It's recognized as an important, if not the most important, single function of a city. So because of this, there is a long-held assumption about that. Now, some may wonder about the enforcement of local laws, how these local ordinances are enforced. Enforcement provisions are set out in the local ordinance or regulation. Most involve fines for violations or misdemeanors. County or city attorneys may be asked to advise those designated to enforce the local ordinance or regulation. Who is asked to enforce the local ordinance or regulation? It could be any number of local entities. It could be the police, the fire department, a code enforcer, a fire marshal. Any number of entities could be asked to enforce, and that would spring into action your county or city attorneys to help interpret the true meaning of the ordinance or regulation. However, in the experience of the Center for Smoke-Free Policy, once the public becomes accustomed to smoke-free public environments, smoke-free becomes the new normal, and many localities have found these ordinances to be self-enforcing. And what I mean by that is that once everyone knows that, for example, in the Lexington, Fayette County urban government area, that it's not legal to smoke cigarettes in a restaurant. People rarely attempt to light a cigarette, but if they do, most other patrons are quick to point out that it's not allowed. And so bringing in other enforcement entities is often not required because these new smoke-free ordinances actually become the norm. Currently, 34% of Kentuckians live in places that protect them from secondhand smoke at the workplace or buildings that are open to the public. As a result, the smoking rate in Lexington, Fayette County dropped from 26% to 17.6%, and the community experienced a 22% drop in emergency room visits for asthma. So now that a number of communities in Kentucky have enacted smoke-free laws, these smoke-free laws have withstood legal challenges and are still on the books, and they seem to be self-enforcing for the most part, and they seem to be having the desired effect in improving public health. What unfinished business do we have with regard to smoke-free policy in our state? Well, one particular area is establishing by case law that health departments in Kentucky have the authority to adopt smoke-free laws. We have a case ongoing right now in Bullitt County that we hope will resolve this issue and will resolve this issue as it is now on appeal before the Kentucky Supreme Court. I'll give you a little bit of history about this. The Bullitt County Board of Health began considering regulations to limit indoor smoking after an air quality study showed that indoor air pollution in Bullitt County was 42 times higher than Louisville's after their smoke-free law was put into place. These findings were presented at a series of community forums throughout Bullitt County, beginning in August of 2010. A public opinion poll in Bullitt County showed that 75% of the citizens favored a local smoke-free regulation. However, the Fiscal Court declined to enact a smoke-free law. So after discussion with community members and after seeking legal advice, the Board of Health adopted a smoke-free regulation. That was on March 15, 2011. The Fiscal Court and 8 cities within Bullitt County sued to stop the health department from enforcing the smoke-free law. The local circuit court upheld the Fiscal Court's request. The circuit judge's ruling was then appealed to the Kentucky Court of Appeals, and the Court of Appeals disagreed. So the Kentucky Court of Appeals reversed the circuit court in Bullitt County by a ruling on December 7, 2012, in favor of allowing the Bullitt County Board of Health to implement its smoke-free regulation. The Court of Appeals held that the Board of Health has the authority to create regulations involving public health. The legislature clearly granted local boards of health the authority to adopt regulations as long as these regulations met several criteria. The criteria were that the regulation did not conflict with administrative regulations of the Cabinet of Health and Family Services. Second, that it was necessary to protect the health of people. And third, it was necessary to carry out the purposes of Kentucky law relating to public health. In previous cases, like Lexington Fayette County Food and Beverage Association versus Lexington Fayette Urban County Government, the Kentucky Supreme Court specifically held that protecting the public from exposure to environmental tobacco smoke can be the proper object of police power of local government. The Court of Appeals also considered whether the ordinances adopted by the Board of Health are reasonable. The Lexington case cited earlier found a similar ordinance reasonable, and the Court of Appeals followed the Supreme Court's judgment. The Bullitt County Fiscal Court appealed to the Kentucky Supreme Court on January 9, 2013, And the Supreme Court agreed on October 16, 2013 to grant discretionary review. There are broad policy implications for departments of public health beyond the narrow question of whether the Bullitt County Board of Health had the authority to enact a regulation, despite the fact that the fiscal court or none of the cities approved of it. There's been some recent writing about this topic, and some people feel that, and have said publicly, that they feel that the concept of a public health department required a wide range of authority for them when they were created. Kentucky statutes are very similar to most other state statutes with regard to the grant of authority. It's very broadly stated to abate nuisances, sources of filth, and causes of sickness. They're allowed to use all things reasonably necessary to carry out their duty. While this sounds very broad, there's a reason for it, and that is that the sources of sickness and disease can be anywhere. They can appear suddenly. They can have rapid and devastating consequences. So, using this kind of authority, not only Kentucky, but states all across the country were able to stop devastating threats like polio, smallpox, diphtheria. All these diseases were stopped or greatly abated by the use of these broad authorities by the health departments. Now, since the days when these were major health threats, health departments have expanded their role. They've looked into things like clean water, safe food in restaurants, treatment of preventative diseases like diabetes, and of course, what is the biggest preventable disease but diseases to the lung and other parts of the body caused by exposure to cigarette smoke. The result of these policies is really indisputable, that the lifespan of Kentucky is longer, their health is better, their quality of life is better, and so these are the rationales behind the broad grant of power to departments of public health regarding their ability to abate nuisances and address health issues. That said, we are still waiting for the Kentucky Supreme Court to render an opinion as to whether, in the case of Bullitt County, the health department overstepped its bounds when it enacted a smoke-free ordinance. So the next piece of unfinished business is whether or not Kentucky should have or would have a statewide smoke-free law. Some Kentucky legislators continue to support the idea of a statewide law restricting smoking. Others like the idea of continuing on a community-by-community basis. One thing is for sure, it will require both state and local elected officials to rid Kentucky of exposure to secondhand smoke in the workplace. City and county attorneys should be aware that a new statewide law, which was under consideration at the time of this recording in the 2014 session of the General Assembly, contains enforcement provisions that may require you to offer opinions to peace officers, employees of public health departments, and others with regard to citations about smoking violations. Again, we don't have a law in place yet, but in the event that we do, it's almost certain that city and county attorneys' advice will be sought. For example, definitions contained in a local ordinance may be changed if a state law is implemented. Also, provisions in the new state law, but not covered in the local law, would have to be addressed. And there are emerging questions that were not considered in the early days of smoke-free policy in Kentucky. This includes e-cigarettes, government vehicles, healthcare facilities, if covered under a state law, but not under local policies. So, the purpose of advocating for a comprehensive statewide law, as Kentucky cities and counties discovered when they enacted their local ordinances, exemptions create litigation points which can be costly for cities and counties to defend, while at the same time failing to protect everyone from the danger of secondhand smoke, and in fact undermining the core purpose for the ordinance. If there are exemptions to the state law or to local ordinances, then children will be more likely to see adults smoking in public places as well as the places they work. And we know that that sort of modeling is what created addiction to cigarettes to begin with. If there are exemptions, people who are trying to quit will be faced with triggers to smoke and will be more apt to relapse. Exemptions mean that workers who are working in any place that's exempted from an ordinance will still be exposed to secondhand smoke. And we know that there is no serious dispute in the medical literature that exposure to secondhand smoke is a known human carcinogen and that it leads to premature death and chronic disease. And finally, all of these factors mean high health care costs for our citizens of Kentucky. So these are the reasons that Kentucky Center for Smoke-Free Policy has continued to advocate for a comprehensive laws, whether they're on the statewide level or on the local level. So with this, we're concluding our presentation. As I said earlier, I appreciate your time and attention. I've been working on this topic with the Center for Smoke-Free Policy for 6 years and have enjoyed counseling with all the localities about their efforts to craft ordinances and regulations that fit with the community desire to improve public health. And I'm excited about the new developments that are on the horizon. As I mentioned earlier, there is a certificate of completion at the end of this webinar, and I thank you very much for your time and attention. Thank you.